tort of defamation. This is number 3 in the syllabus under module 1 of unit 2. At common law, defamation is defined as the publication in any form of any statement which injures the plaintiff's reputation by exposing him to hatred, ridicule, or contempt, or which tends to lower him in the esteem of right-thinking members of society. This was taken from the case of Lord Atkin in Sim and Stretch. A defamatory statement may either be libel or slander. It's very important to know the differences between the two. So libel is a defamatory statement in a permanent form. So it may consist of written words in a newspaper, a book, a pamphlet, a letter. Defamatory words are uttered, or that are uttered in radio and television broadcasts, are normally treated as being in a permanent form. That is as libel. And this is due to the wide impact of such forms of publication. Now, slander is a defamatory statement as well, but in a transient form. So principally by means of spoken words or gestures. So defamatory words contained in audio discs, cassettes, tape recordings, or any such or similar medium would usually be considered libel. So the difference between libel and slander. When it comes to proof of damage, the main difference between the effects of libel and slander is in the proof of damage. Libel is always actionable per se, that is, without proof of damage. Right? In slander, however, there must be proof of damage, except in certain instances, which we will discuss later. So if the defamatory statement is libel, the law presumes that the damage has been caused to the claimant's reputation. He will be awarded general damages in any event. If he does prove that he has suffered actual loss, he will be compensated further by way of special damages. As opposed in slander, the claimant has no cause of action unless he can show that he has suffered actual loss. He may have been dismissed from his employment or been refused credit by a bank, for example. The mere loss of consortium or the company of friends is not sufficient. So if your friends or the people you associate with on a daily basis no longer want to associate with you, that does not count as loss for the purposes of slander. Right, so in the case of Sunana Singh and Ram Kher Singh, the facts of this case: at an East Indian meeting, the defendant had alleged that the plaintiff had cohabited with his sister-in-law and that she had become pregnant by him. The plaintiff alleged that in consequence he had been banished from the society of the members of his caste. He sued the defendant for slander. This case held that the plaintiff's claim disclosed no cause of action, because to succeed in the tort of slander, he must prove that he had suffered special damage of some temporal benefit. Mere loss of the consortium of friends and associates was not sufficient. There are exceptional cases, however, where slander is actionable per se. So in certain exceptional cases, slander is actionable without proof of damage. These are the cases where there's imputation of a crime, or having a disease, or adultery, or misconduct in a professional trade. So imputation of a crime, the defendant alleges that the claimant has committed a serious crime, one punished by imprisonment, such as theft or a drug offense, for example. Such slander is actionable per se. Right? There must, however, be a direct assertion of guilt. Mere allegation of suspicion is not sufficient. Right? The words, you must remember that the words may only be slander if spoken, and is only actionable per se if written. Generally. Right? Imputation of certain diseases. So where the defendant alleges that the claimant is infected with a certain contagious or repulsive disease, the words are actionable per se, since this would tend to cause other persons to shun or avoid him. Imputation of adultery, for example. This is an exception that has been created by statute. The Libel and Defamation Act of Trinidad and Tobago provides that words spoken or published which impute or suggest adultery to any woman or girl shall not require special damage to render them actionable. And so, for example, in the case of Ram Kilawan and Motilal, the defendant called the plaintiff, who was a respectable married woman, a nasty prostitute in the presence of other witnesses and accused her of having brought men to her house. She then sued for slander. The defenses were that she could not prove that she had suffered any special damage, and in any event the words amounted to mere vulgar abuse. However, it was held that the words amounted to slander in the circumstances and were actionable per se. Another head, imputation affecting the personal or business reputation. So where there are such statements, for example, the doctor is incompetent or a lawyer doesn't know any law, the trader is fraudulent or the banker is fraudulent, these words amount to a disparagement in the way of the claimant's professional business. The words, however, must be spoken of a person following a calling or spoken of him in that calling, which imputes to him unfitness for or misconduct in that calling. So that's been in relation to their job. Right? So in the case of Gordon and Pandy, the plaintiff was the proprietor of the Guardian newspaper, which is a newspaper in Trinidad and Tobago. The defendant was at the time the Prime Minister of Trinidad and Tobago. During a speech on Indian Arrival Day, the latter had referred to the former as a pseudo-racist. The speech was widely reported in the press. The claimant claimed that not only for the original publication, but for the repetition of the libel in other publications on the basis that the repetition was, in the circumstances, the natural consequence of the publication by the original publisher, and it was foreseeable that republication would have happened. It was held that defamatory imputation disparaged the plaintiff in his profession and calling in the media business. So it reduced his standing in the media business. It affected the way people would see him as a proprietor of a newspaper. The defendant implied that the plaintiff had used or misused racism in order to maintain a monopolistic advantage over his competitors in the business. The defamatory statement that the plaintiff was a pseudo-racist was made in a speech on Indian Arrival Day. The speech was widely reported in the press, and the court further held that the defendant both impliedly authorized and intended his slander of the plaintiff would be published throughout the length and breadth of Trinidad and Tobago and abroad. Right, so ingredients for a successful defamation case. What the plaintiff must prove. So the plaintiff must prove that the statement was 1, defamatory, 2, that the statement made reference to the plaintiff or the claimant, and 3, that the statement was published. So 1, the words must be defamatory. The first ingredient in the tort of defamation is that the claimant must prove that the words used were defamatory to his character. Right, so there are 2 stages. Right, so where the words are clearly defamatory on their face, they are almost invariably defamatory in the circumstances in which they were used. But where the words were ambiguous, the court must decide what the ordinary reader or listener of the average intelligence would understand by the words. It is irrelevant that the defendant did not intend the words to be understood in a defamatory sense. The intention of the defendant must be relevant to the assessment of damages, but it is immaterial in determining whether the words were defamatory or not. Right? And then there's something called an innuendo, which you must note, where the words are not used, or where the words are not clearly defamatory on their face. The claimant must allege an innuendo. Innuendos are of 2 kinds. One, a true or legal innuendo, and secondly, a false or popular innuendo. In a true innuendo, the words are innocent on their face, but they are defamatory because of some special facts or circumstances not set out in the words themselves, but known to the persons to whom the words were published. So to say that the plaintiff is a frequent visitor at number 10 Sesame Street or at Murray Street, for example, in Trinidad and Tobago, is perfectly innocent on the face of the words. But if that address is of a brothel, then the statement would carry the innuendo that the plaintiff is associated with prostitutes, and that would be defamatory. So in the case of Cassidy and Daily Mirror newspapers, a newspaper published a photograph of Mr. C and Miss X with the caption, Mr. C and Miss X, whose engagement has been announced. Mr. C then sued, claiming that the words imputed an innuendo that she was living immorally with Mr. C. It was held that those words were defamatory to Mr. C's wife, Mrs. C, since persons who knew she had been living with Mr. C might believe that she was not his wife, but had been immorally cohabiting with him. A false innuendo is a defamatory statement which a reasonable person might draw from the words themselves. So, where a bank wrongfully returns a check to a pay stamped return to draw, such a statement is defamatory because it carries the inference or innuendo that the drawer is dishonest. A statement which tends to lower a person's reputation, not in the minds of right-thinking members of society generally, but also in the minds of a particular section of the community, such as members of a private club, however, is not defamatory. And this was stated in the case of Brian and Dean. So examples of a defamatory statement. So this would be statements that state that a businessman is involved in a cocaine trade, a corporation checks bonds, a claimant had stolen money, a married woman was a prostitute, the claimant had associated with a person infected with HIV/AIDS, etc. All of these are statements that would be considered defamatory by the court. So the second limb, the words must refer to that of the claimant. So the second requirement for a successful action in defamation is that the defamatory words must have been shown to refer to the claimant. The claimant, however, does not need to be mentioned by name. It will be sufficient if his initials or his nickname are used. He may be depicted in a cartoon or photograph or a verbal description. He may be identified by his office or post. The question is whether a reasonable person would understand the defamatory statement as referring to the claimant. Right? So, in the case of A.G. and Milne, a radio broadcaster referred to one irresponsible businessman who pledges $500,000 on placards, posters, and other subversive material. The plaintiff sued for defamation. The defense was that the words could not reasonably have been deemed to refer to the plaintiff as he was not named. It was held in that case that it was sufficient to make reference to the plaintiff for him to be able to maintain action for defamation. So the words that they use, everybody would have known who that plaintiff was. There's $500,000 on placards, everybody would know, oh, that's who they're talking about. Right? In the case of Gary and Bullen, a newspaper article alleged sexual impropriety by the plaintiff, Prime Minister of Grenada, towards young girls seeking employment. It was held that the article contained sufficient reference to the plaintiff because a substantial number of ordinary sensible persons who knew the plaintiff reading the article would believe that it referred to him. In the case of Halton and Jones, the defendants published a fictional story in their newspaper concerning the adulterous exploits of one Artemus Jones. A real person named Artemus Jones, who was a barrister, existed. He sued the defendants for libel, and it was held in that case that despite the fact that the use of his name was accidental, defamation did indeed occur, and he was successful in his claim. So thirdly now, the words must have been published in order to be defamatory. The third ingredient which a claimant must prove is that the words of which he complains were published. This means that they must have been communicated by the defendant to at least one person other than the claimant himself. Every repetition is a fresh publication and creates every repetition is a fresh publication and creates a fresh cause of action. In a libel containing a newspaper, the author, the editor, the publisher, the printer, and even a news agent or street vendor will be liable. So again, in the case of Gordon and Pandey, the plaintiff was the proprietor of a newspaper, and the defendant was the Prime Minister, as I mentioned before. And during the public speech on Indian Arrival Day, the latter had referred to the former as a pseudo-racist. His speech was widely reported in the press, and the claimant claimed not only for the original publication but for the repetition of the libel in other publications on the basis that the repetition was, in the circumstances, the natural consequence of the publication by the original publisher. That is, the publication was foreseeable, and it was held that the defamatory imputation disparaged the plaintiff in his profession or calling in the media business. The defendant implied that the plaintiff had used or misused racism in order to maintain a monopolistic advantage over his competitors in the business. The defamatory statement that the plaintiff was a pseudo-racist was made in a speech on Indian Arrival Day, and the speech was widely reported in the press. It was also held that the defendant both impliedly authorized and intended that the slander of the plaintiff would be published throughout the length and breadth of Trinidad and abroad. It is not a defense that in publishing a defamatory statement, the defendant was merely repeating what someone else told him. The publisher cannot escape liability by prefacing the defamatory statements with the words, "It is rumored that." So now we look at the defenses available in defamation. So there are 4 defenses in defamation. And so these are justification, fair comment, absolute privilege, and qualified privilege. So justification. This amounts to saying that the defamatory statement is the truth. It is a complete defense to an action for libel or slander to prove that words complained of were true in substance. A claimant cannot recover damages for injury to a character he is not in fact entitled to bear. It must be true in substance. If it is inaccurate only in minor details, the defense will still succeed. Where the defendant repeats a defamatory statement originally made by someone else, he must prove that that statement was true, not merely that it was made. So in the case of Brewster and Trinidad Publishing Company, a newspaper article reported that a patient had sued a nursing home and a doctor for medical negligence. It repeated the particulars of negligence contained in the plaintiff's statement of claim. They alleged that the patient had received inexpert, unskillful, and unprofessional treatment from the plaintiff. The plaintiff sued for libel. The defense was that the newspaper had reported only the specific allegations contained in the pleadings, and this enjoyed qualified privilege. It was held that the newspaper had libeled the plaintiff by repeating the words in the writ and could not rely on qualified privilege or justification. The second defense is fair comment. So it is a defense to an action for libel or slander that the statement complained of was fair comment on a matter of public interest, as the defense preserves the fundamental right to freedom of expression. For this defense to succeed, however, there are certain requirements. So firstly, the matter must be one of public interest. So such matters will include the affairs of the government or the administration of justice, or the management of public institutions. Secondly, the statement must be a comment or an opinion and not an assertion of fact. So the defamatory matter must appear on its face to be a comment or opinion and not a statement of fact. If it is a statement of fact, the defendant will have to rely on justification. Thirdly, the comment must be based upon true facts. A comment or opinion is not protected if it is based on untruth, as is seen in the case of Salty Sick and Julian, Soltysyk and Julian. Also in the case of Ford and Shan Trinidad and Tobago Newspaper Publishing Group Limited, the Mirror newspaper published on its front page an article which alleged that the plaintiff was presently carrying on a steamy affair with a minister of government, and that the plaintiff had earlier been romantically linked to a showbiz impresario who had died from AIDS, and that she had subsequently herself died in Jamaica, and her body had been shipped back to Trinidad under an assumed name. The plaintiff, however, was in fact alive and well. There was no evidence that she had been romantically linked to any impresario, nor was there any proof that the person had died. It was held that the article was defamatory to the plaintiff, since ordinary persons would draw the inference that she had indulged in several affairs with a number of men, and further that she had become infected with the AIDS virus, and this would cause ordinary persons to shun and avoid her. The defense of fair comment failed because the words complained of were not comment but a series of statements of facts. Right? So fourthly, the comment must be honestly made. Honestly means genuinely held. The defendant will have a defense if he expresses his genuine opinion on the subject matter, even though his opinion may have been biased, prejudiced, or exaggerated or irrational. If he ascribes base, dishonest, or corrupt motives to the claimant, he steps outside of the boundaries of the defense. Fifthly, the comment must not be actuated by malice. So the comment must not be made corruptly or with a wrong motive or used for some indirect purpose, as shown in the case of Clapham and Daily Chronicle. Now, freedom of speech is a fundamental right under the Constitution. Like other fundamental rights, it is a freedom that must be enjoyed under the law. The law must maintain a balance between the right of the individual to his unsullied reputation if he deserves it, and the right of the public to express their views honestly and fearlessly on matters of public interest, even though that involves strong criticism of the conduct of public people. In the case of Craig and Miller, the court held a defendant to be liable for slander, as the court pointed out that there is no law which places public figures in a worse position than other members of the public for protecting their reputation from charges of serial breaches of criminal law. There is no provision which abrogates the rule of law during the conduct of a political campaign. So it just goes to show that even if it's a public figure like the president or the prime minister, and you may think that it is fair game, the court will still view or have to consider the words used and may well deem them defamatory. So the third defense is absolute privilege, and this arises in circumstances where public policy demands that persons in those circumstances should be able to speak or write with absolute freedom without fear of liability for defamation. Absolute privilege is a complete defense to an action for defamation. However false or defamatory the statement may be, and however maliciously it may have been made. So, for example, statement made in the course of and with reference to judicial proceedings by any judge, juryman, advocate, party, or witness. So, for example, anything a witness says in the witness box with reference to the subject of the proceedings is protected, even though the statement may not be relevant, accurate, and may be maliciously made, for example. And this was held in the case of Bowden and Brandon. B. Reports of judicial proceedings are fair and accurate and contemporaneous reports in a newspaper of proceedings publicly held before any court is absolutely privileged. C. Statements made in proceedings of legislature. This privilege covers statements made in debate or in committee and includes statements made by witnesses called to give evidence before a committee. D. Communications made by one officer of state to another in the course of his official duty. So this privilege extends to high-ranking officers such as ministers, ambassadors, and high commissioners. And this was shown in the case of Chatterton and Secretary of State for India. For defense, qualified privilege. Both absolute and qualified privilege give protection to persons who make defamatory statements in circumstances where the common convenience and welfare of society demands such protection. Whereas absolute protection is limited to the few well-defined occasions, qualified privilege applies to a much wider variety of statements. So in qualified privilege, the defense will be defeated if the claimant proves that the defendant was actuated by express malice in publishing the words complained of. So, 1. Statements made in the performance of a legal or moral or social duty. So this defense applies to when the defendant shows that he was under a legal, moral or social duty to communicate the defamatory matter, and the party to which he communicated the matter had a corresponding duty in receiving it. An example of the legal duty is where the defendant makes a report to a police officer accusing the claimant of having committed a crime. Qualified privilege. So in the case of Stewart and Green, the defendant was a police constable investigating a report of arson. He said to the plaintiff at a dance hall in the presence of other persons, "I put it to you, is you burn down the house? Is you burn down the house?" And it was held by the Court of Appeal that those words were qualifiedly privileged. In the absence of malice, the defendant was not liable in defamation. B. The statement made to the proper authorities in order to obtain redress for public or private grievance. All of this is under qualified privilege for defense. A private grievance means a grievance suffered by the defendant as an individual. A public grievance is one which affects the general public and which any member of the public, whether he is personally affected or not, has an interest in bringing to the attention of the proper authorities. Where a person believes that he has suffered a grievance at the hand of another, he is entitled to bring his grievance to the notice of the person or body whose power or duty it is to grant redress or to punish or reprimand the offender. Thirdly, statement made in self-defense. A defamatory statement made in order to protect the defendant from an attack upon his reputation or property by the claimant enjoys the defense of qualified privilege. In defending himself, the defendant is not entitled to make unnecessary imputations on the private life of the attacker, which are wholly unconnected with the attack and irrelevant to his vindication. So in the case of Osborne and Bolter, 1930, a publican had complained to the brewery which had supplied him with beer for sale to his customers that the beer was of poor quality. The brewery replied, copying it to a third party, that they had heard rumors to the effect that the poor quality of the beer was due to it being watered down by the publican. It was held that the statement had the benefit of qualified privilege since it was made in defense of the defendant's own property and reputation. Fourthly, statements made between parties having a common interest. So this privilege may arise in a wide variety of cases. The common interest may be pecuniary, and an example of this is when an insurance company writes a policyholder warning him against dealing with a former agent of the company. Fifthly, a fair and accurate report in a newspaper, radio, or television proceeding in legislature or of a court of law. So the report must be fair and accurate, and the defense of qualified privilege will not apply if the report alleged that the certain statements were made were not in fact made. So if certain statements were allegedly made by the newspaper, but it was shown that it was not made, then the defense is not available. Sixth, a newspaper's statement is privileged under statute. So in Guyana and Jamaica, there are various classes of statements published in a newspaper or on radio that are statutorily privileged. And I don't think that applies to Trinidad and Tobago. And seventh, political discussion in media. An important issue is the extent to which citizens and the media are free to criticize politicians and other public figures without fear of liability for libel if they get the facts wrong and cannot prove them to be true. The defendant must establish that there was a duty to publish to the public and a corresponding interest in receiving it. And the case, the locus classicus, the main case on this is Reynolds and Times newspaper. Reynolds and Times newspaper. It was held in this case that a discussion of political issues in a newspaper or on television or radio would be protected by qualified privilege even though it might contain defamatory or untrue statements provided that there was no proof of malice. The defendant must establish that there was a duty to publish to the public and a corresponding interest in receiving it. In deciding whether a defamatory statement which misstates facts was published in the media or published in public interest and on an occasion of qualified privilege, the court must take into account the following: the nature of the information, the extent to which the subject matter was of public concern, the seriousness of the allegation, the source of the information, the steps taken to verify the information, the status of the informant, the urgency of the matter, whether comment was sought from the plaintiff, whether the article contained the gist of the plaintiff's side of the story, and the overall tone of the article. This is known as the Reynolds test and is not an exhaustive one, but has been established as a test in circumstances like this. So, remedies for defamation. The principal remedies asked for in defamation actions are usually damages and injunctions to prevent further publication. The essential aim of an award of damages in a defamation action is to compensate the claimant for the injury to his reputation. Some of the factors which the court takes into account in coming to an appropriate figure of general damages for defamation include the nature of the libel, the circumstances of the extent of its publication, the conduct of the defendant from the time when the defamatory matter was published to the time of the judgment, the social and or professional status of the claimant, whether the defendant persisted in a plea of justification which eventually failed, whether the libel was published deliberately and willfully or merely by mistake or carelessness, whether the defendant made an apology to the claimant, whether there was any express malice on the defendant's part, the claimant's bad reputation, and whether an apology has already been published, however, may serve as mitigating factors in a matter of defamation. And this is the end of defamation. This is a very condensed lecture because of the timing of the video in relation to CAPE examinations. I'll continue to post more, and like and subscribe.